Good afternoon. This is Alan Crone. I'm the managing member of the Crone Law Firm, and we are an employment law firm in Memphis, Tennessee, and we represent employees, executives, and entrepreneurs in legal disputes and legal matters that affect their ability to make money. And this is the next in our series of Facebook Live chats where we're discussing frequently asked questions about different areas of the law sent in by our clients and other folks who view these broadcasts. So I hope this is helpful, and I'm looking forward to discussing today with you the Americans with Disabilities Act. So the first question about the Americans with Disabilities Act is, well, what is the Americans with Disabilities Act? And that is a wide-ranging act that was passed in the 90s to afford folks with disabilities reasonable accommodations in public accommodations, public spaces, and also at the workplace. And we're going to focus today on the workplace and leave public facility accommodation for another time. But to be covered by the Americans with Disabilities Act, you have to have a disability, and that's some sort of medical condition that affects a major life activity. And a major life activity could be just about anything. It could be walking, it could be sleeping, breathing, working, climbing, anything that's a major life activity. And the most obvious examples of disabilities are folks who have to use some sort of apparatus for locomotion, things like wheelchairs or crutches or walkers or that sort of thing. But it can also be mental impairments. It can be visual impairments, any number of physical attributes or injuries which affect your ability to engage in these major life activities. So who's protected by the ADA? In the workplace, all employees are protected by the ADA as long as your company is covered by the Americans with Disabilities Act. In Tennessee, the Tennessee Human Rights Act also covers disabilities, and so that's anybody with employees of 8 or more, and in larger organizations are also covered by the federal Americans with Disabilities Act. And the next question is, can I get fired for having a disability? Well, yes and no. If you can't be fired or discriminated against if you have a disability, if you're otherwise able to perform the essential functions of your job with or without a reasonable accommodation. There's some jobs where a disability is not an impairment, but people perceive that it's an impairment, or sometimes people perceive that a worker has a disability that they don't really have. In either case, as long as you can perform those essential functions of a job, you can't be fired or demoted or not hired because of your disability. Now, sometimes the disabilities do interfere with the essential function of the job, but they can be overcome with a reasonable accommodation. And a reasonable accommodation is a case-by-case inquiry usually, because one of the factors you have to weigh is how intrusive is the accommodation to the workplace, but also how expensive is it? Is it expensive to acquire? Does it increase the cost for the business to have the accommodation in play? Let me give you an example from a case that I had where the reasonable accommodation was very, very simple. I had a client who had a disability in her knees. The condition in her knees affected her ability, the major life activity of walking, sitting, and standing. And the only thing her doctor asked the company to do, she worked in a large kitchen and she cleaned plates, and she was a dishwasher. And there were about 3 or 4 folks who worked in this one area, and they were in a typical kitchen, had a tile floor, very hard tile terrazzo floor, and her doctor said that her condition, which was sharp pain in her knees, so sharp that she couldn't work when she got that pain in her knee, and her doctor said it was caused by standing on the terrazzo floor. And if the company would provide a $50 cushion for her to stand on, kind of a commercial industrial mat made of rubber, that would alleviate the pain in her knees. Well, the company refused to provide that accommodation. They said, well, if you get one, then everyone will want one. And the court eventually said that was crazy. A, it wouldn't be a bad idea to give everybody a mat. And B, not only was she willing to provide her own mat, thus reducing the cost to the company, but that the other employees said that they didn't want a mat anyway. So that's a very simple example of an accommodation that's very reasonable to provide, a $50 mat, which alleviates the condition, and that allowed her to perform the essential functions of her job. You also have to be careful to look at the essential functions of the job and determine if they really, really are essential to the job. And this is an area where employers really need to make sure they review their job descriptions frequently, because if there's a job description, if there's an element of the job that's written in the job description upon which they're relying for not providing a reasonable accommodation, or claiming that the person can't perform this particular essential function of the job, they need to make sure that it really is an essential function of the job. I had a client once who couldn't lift more than 75 pounds, and that was a requirement in the job description. Well, as we conducted discovery, we discovered that those particular employees in that job classification rarely, if ever, had to lift more than 50 pounds, much less 75 pounds. So it's important for employers to really scrutinize their job descriptions to make sure that they're accurate, so that they don't get second guessed in the event of a discrimination claim. The next question is, what are my employer's responsibilities under the Americans with Disabilities Act? Well, one of the primary responsibility that your employer has, if you have a disability and you come to them and say, I'm having trouble because of my disability, well, the first thing they have to do is to treat you fairly, to treat you the same as everybody else. They can't treat someone with a disability or someone they perceive as having a disability differently than any other worker. The next thing that they have to do is they have to engage in a process with you where you communicate over what a reasonable accommodation might be. They need to sit down in a collaborative way and discuss reasonable accommodations, what you or your doctor think would be a reasonable accommodation, suggest alternatives, and work in good faith towards setting up a win-win for everybody. And by that I mean a win for you, because you can then perform the essential functions of your job with this particular reasonable accommodation, and a win for them because they get to keep a good employee and they get to stay productive and they get to stay in compliance with the law. How do I file a claim with my employer under the Americans with Disabilities Act? Well, that really depends on the particular employer. Usually you want to start with human resources. Certainly want to start with your supervisor. If your company isn't large enough to have a human resources department, you may have to go to your supervisor's boss, depending on how receptive your supervisor is to your request for a reasonable accommodation. Request for a reasonable accommodation can mean some time off. There's a certain interaction there with the Family Medical Leave Act, which we've discussed in other broadcasts, where you have a certain number of days that you can take leave, and you can use that leave intermittently, and sometimes rescheduling or light duty are all things which are available under the Americans with Disabilities Act, and your company ought to engage in that collaborative process with you to make sure that you are getting the kind of accommodation that you need. If you start hitting your head against a brick wall and the company isn't doing the right thing, they're not following the law, or you believe they're not following the law, then you need to go to the EEOC, the Equal Employment Opportunity Commission, and file a complaint there, or go find an employment attorney who handles these types of cases and consult with that attorney. We talk to people all the time who are still employed and try to help them resolve it without escalating the problem any farther. Sometimes companies, if they haven't had a whole lot of experience with the Americans with Disabilities Act, they just don't understand what's involved. They don't understand their responsibility to engage in an interactive process. They don't understand what a reasonable accommodation is. Sometimes they don't understand that just because they're worried about a person's ability to do their job based on their perception of what the downsides, for example, of a disability is, that doesn't mean that they can then be paternalistic and take action in that way. I had a client once who had MS, and all he wanted to do was work. And he had to be carried to his workstation, and carried away from his workstation, but he was otherwise able to perform the job. A safety manager saw him and became concerned that he was a safety risk. Well, without any real reasonable probable cause, singling him out was discrimination because of the safety person's perception of his disability. But he was otherwise able to perform the essential functions of his job and should not have been harassed about his physical condition. And so very frequently we can engage in a process, or an attorney can engage in a process with the company, and through that process educate them what their responsibilities are, and very frequently that can solve the problem, either for a time or indefinitely. Sometimes if you have a supervisor, however, who sees this not as an opportunity for the company to excel or for an employee to excel, but as a hassle, one more thing they have to do that they're not getting paid for, then they can start to engage in retaliation, and you really ought to nip that in the bud. You can't be retaliated against for making these kinds of claims or reports or requests for an accommodation. The law in this area is very complicated, and it really requires someone who not only knows the law but has had extensive experience in dealing with these kind of claims. And so whether you go to the EEOC or not, you really should seek out an employment attorney who can help you navigate these waters. As I said many times, it's simply a matter of educating the employer. Sometimes it's a matter of calling the employer on practices that the employer knows are not proper. And once you get an attorney, then they snap into action. And sometimes you have to negotiate a severance agreement, an exit strategy, because the company would rather pay the worker off than do what's right. And so we help folks with that all the time, and there are other attorneys that will help you with that. My best advice on that is not to just endure it, but to take some action and stand up for yourself, because you do have rights, and what the Americans with Disabilities Act aims to do is to provide everybody an even playing field to be productive and to enjoy the fruits of their labor. And I hope that this short broadcast has been helpful. I always enjoy talking about these matters. So if you have any questions or you have any suggestions for future broadcasts, please leave it in the comment line. And if you've enjoyed this broadcast, please share it on Facebook so that it might reach a larger audience. Again, my name is Alan Crone. I work at the Crone Law Firm. Thank you very much.